Okay, my name is Nicolene Le Roux, for those who don't know me, and I'm the Director of Development, Compliance and Legislation. I'm the part in between. So you've got your land use applications that start with your rezoning or your township or your subdivision or your sectional title. Then you've got an implementation process, which is your post-approval. In other words, there's a process whereby your rights have to come into operation or be adopted, as Tolo has also said. Then only do you get to your site development plan and you do your building plan. Now, I didn't do a presentation because I would rather let you ask me questions. So there are three things I'm going to deal with today. Subdivisions, sectional title schemes, some of the legalities around servitudes and all of those issues. If you want to ask me about the title deeds, you can ask me about the title deeds, and then specifically the legislation. So I'm going to start with the legislation. I think everybody understands that there's new legislation called SPLUMA. Who doesn't know about it? Everybody knows about it. And what SPLUMA has done is it changed the landscape of land use applications. Now, the guys that are suffering the most, I think, is the group in this particular room. The reason being that SPLUMA, in the past, if you had land use applications and you had land use rights, once your land use rights have been approved, it doesn't lapse at all. You can actually continue with your land use rights ad infinitum after proclamation, and it's going to be in place. But what SPLUMA has done is that you cannot retain your rights. So if you've got, for instance, a subdivision, and the subdivision is approved, you have to comply with your conditions of subdivision within 12 months, and we can give you extensions of time, but only for a maximum of 5 years. This is not the Tshwane municipality, even Klerksdorp will have to comply. This is a national piece of legislation, which is your framework legislation. So all municipalities had to go and put in the detail in your bylaw. In other words, they set the parameters, we have to fill in the detail. So in terms of land use applications, you guys must make sure that by the time you submit your site development plan or your building plan, that you still have valid rights. Because the town planner, once he's got his approval, he disappears. And the rights are going to disappear with him if your client does not comply with his conditions of approval. So if he does not comply with his conditions of approval, section 43.2 of SPLUMA says your land use rights lapses. Okay. Section 43.2. Okay. So 43.2 will tell you the maximum is 5 years, but the bylaw puts it in bite-sized pieces of a year and a year until you get to your 5 years. The reason why we did this in the bylaw is because of the fact that we almost need to remind the owners that it's going to lapse. Okay, we can't have somebody coming on 4 years and 9 months and then try and comply with these conditions. So the moment your application is approved, you need to start dealing with your conditions. And this is not Tshwane. It's not the municipality, this is a national piece of legislation. So please be aware of this.
Historic rights that haven't been executed on?
Okay, there are time frames here. Okay, just to answer the thing about the old building and an alteration and can you apply the new rules to the old building. Remember, legislation never works retrospectively. So if something was legally done in terms of particular legislation, it is lawful insofar as that legislation is concerned. When you've got new legislation, you apply the new legislation. So you never apply it retrospectively. So there was a time frame before SPLUMA, that is the 1st of July 2015. Everything that went before 2015 were dealt with in terms of the Town Planning and Townships Ordinance. Those rights are in place. They can be executed and they will be promulgated. Everything after the 1st of July until the bylaw came into operation will comply with SPLUMA. Okay? So you need to look at the date of your approval. When your town planner hands you an Annexure T, the fact that it's a signed Annexure T does not mean that the rights are in place. There are processes to enter into, and it's not just rezoning. So if you've got a rezoning, the process will be you've got an approval, you have to comply with your pre-promulgation conditions, and only once you've complied with those conditions do we publish, and then your rights are in operation. If it is a consent use, your rights are not in place when you've got a consent use. You need to comply with your conditions of your consent use. Then once having shown that you've complied with it, it will then go to our LULAS section, and then they will link it. Now, this linking, let me explain this. Once your rights are linked, that's when you get a zoning certificate. So if you go to the information counter and you can't get a zoning certificate, it means this process was not concluded. Okay. If you can get a zoning certificate, it's safe for you to assume that the rights are in place. So the first question you ask is, can you get a zoning certificate in order for you to do your SDP and your building plan? And then you know whether your rights are in place. So please be aware of the fact that these things can lapse, unlike in the past. A site development plan. So there are 4 categories of conditions. Let's talk about that. So your first set of conditions, which you will see in the new approvals, will be all those conditions to be complied with prior to coming into operation. An SDP is not a requirement for rights to come into operation. An SDP is a condition of the exercising of rights. So it can never be one of the ones in the front. So an SDP is a requirement of your land use rights. And it will not prevent you from if you submit your SDP and it's refused, it's got nothing to do with your compliance for purposes of linking and for purposes of getting your rights into operation. So yes, you can submit your SDP, but it's the exercising of your rights, which is later. It's not a condition of getting your rights in place. It is the exercising of your rights, which is after your rights are in place. Okay, so in the past you had a land use application that was approved. Okay, then in terms of section 57 of the ordinance, it said you shall forthwith proclaim or promulgate. Then you will have a contribution letter, and you may not submit your building plan until you've paid your contributions. So that's the old dispensation. Now with SPLUMA, it's a different dispensation. So you've got an approval. But before you can proceed with bringing your rights into operation, you need to comply with your conditions relating to bringing it into operation. Now, what are those conditions? In the past, you will get your rights in operation, and then you pay your contributions. One of the things that have changed is that you have to pay your contributions before we will allow you to exercise your rights. So examples would be payment of contributions, the registration of certain servitudes. These are the type of conditions, but I cannot give you an exhaustive. I'm not a building control officer that works with lists. These will depend on the type of conditions that relate to the land use. Then, having done your conditions for purposes of bringing it into operation, you will then promulgate your application, and that's it. That's where the process stops. So by the time you promulgate, we will link your rights, and you can go to the SDP and the building plan process. Okay. The reason being that these rights were all done speculatively, and the contributions never get paid, and we need to update the contributions. Now, you'll hear the word development charges a lot, because SPLUMA went and they changed the terminology. So they don't talk about engineering contributions any longer, it's development charges. And for those of you who want to give comments, there's a bill that is coming out from National Treasury where they are going to set a guideline for how you calculate development charges within a municipality. And they're going to have unit costs. So if you've got business for, this will be your contributions. If you've got residential one, this will be the contribution. So look out for the bill and do your comments if you are interested. So all of this will be done. So everything that is necessary in order for you to get to a point where you can exercise your rights will have to be complied with first, and when we promulgate, your rights are in place. Okay, let me just explain the lapsing. Remember that if you take a decision on a land development application, there are processes, but this is not a decision by council to lapse your township or application. This is what is called an ex lege lapse. In other words, it's like your driver's license. If your driver's license lapses on the 1st of March 2018, it is not somebody sitting there and deciding that you are lapsing the thing. It automatically, by legislation, lapses. So even if you didn't make the date, there's nothing the council can do. We can't reinstate, we can't help you because it's a failure and the legislation took the decision, not us. Okay, so it says, failing which it shall lapse. Your 12 months start ticking, okay? Promulgation stops the clock, your rights are in place. So your clock starts on the date of notification. In other words, when the applicant is notified that his application was approved, 12 months from that, you need to get all of these conditions in place, you need to comply, and then we will promulgate your application. So it starts there. Now, the way in which extensions of time work. Remember, if you've got 12 months and your 12 months ends on the 31st of March or the 30th, how many days are in March? 31st of March. You have to apply for your extension of time prior to that date, okay, to keep it alive. You can't wait after and say, well, I want an extension of time. Once the legislation kicks in, there's no condonation. The municipality does not have condonation powers to say, we'll condone the fact that it's late. Okay. So when you are dealing with your client, you don't need to know all the detail. What you need to know is, from your client, are your rights in place? Have they been adopted if it's a consent use or a subdivision or whatever? And have they been promulgated if it's a rezoning? Otherwise, you're going to go to submit your building plan, and 12 months later you find out that the thing has actually lapsed and the building plan will never be approved. Okay. So this is the change in dispensation that SPLUMA has brought in. Okay. So as much as we would like to take a credit for the change, it wasn't the City of Tshwane and its bylaw. It was SPLUMA. Okay. We are just filling in the blanks because we need to determine the processes. Now what we did is, for the town planners, not necessarily for you, we sent out a circular to just remind them that there is a possibility of lapsing because they don't seem to read all the legislation. When SPLUMA was written and we went to the Parliamentary Portfolio Committee and everything, the principle was that a municipality has a 5-year cycle. You've got 5-year elections, every 5 years you kind of redo your policies and everything. And it doesn't make sense to allow a latent right to lie there unendingly. That's what happened with the Zonke Sizwe Grand Central applications, where they just kept giving extensions and extensions and extensions. And while they were, at the time of the approval, there were services available. Everybody else develops, and the services that were retained for purposes of these townships were taken up. Now you want to start with these townships, they're dead. Okay, because there are no services. So do you understand that SPLUMA has changed the game plan a little bit? Okay. So if we now go on to the next thing, which is consolidations and subdivisions, because that's the important thing. You can't take the date of the decision because it's not known to the applicant. So let's say he gets it a month later, then you steal a month. Here's the 1986 ordinance. Okay, before that, the 1965, which we still have applications in terms of. So when the 1st of July came, okay, these applications that we had in terms of the old ordinance, they are going to be finalized in terms of the old ordinance. The only problem is, insofar as section 57 and 58 is concerned, the reason why it was done this way, I didn't want to go into the detail, but let me do that. The reason why it was done this way is because your appeals were based post-promulgation. I hope you know this. So you only appealed your decision once it's promulgated, and your appeal would have gone to the Townships Board, agreed. Now, your appeal is within 21 days of this decision, okay? And if you appeal, you can't appeal. Yes, 21 days of notification. Now, if you appeal, there is no Townships Board. I'm sure you all know that. The Townships Board's dead. So the appeal process can no longer be dealt with in that way. So even though it is an ordinance application. The finalization will be exactly the same. So your decision will be done, you will do your conditions, and then we will promulgate. Because section 63, which deals with your contributions, the Townships Board, there's a number of things that don't exist anymore on the law books. Okay. But again, that is a process that was basically turned on its head because of Spluma. Okay. But that's more for town planners, but just for interest sake. Okay. Subdivisions and consolidations. Can we deal with that quickly? Now, under consolidations and can you guys see this board? Okay. Consolidations and subdivisions, I want to explain a few things regarding that. So if you've got a consolidation, okay, it's two properties, property 1 and property 2. There are different scenarios for consolidations. If these two properties was the subject of a rezoning that related to two stands, okay, and the condition says that the properties must be consolidated, then the rights are going to approved across boundaries like this. It means you can develop as you want to, because they were both the subject of one amendment scheme. But we get instances where you've got a property A, B, C, D. This is on amendment scheme 2, and this is on amendment scheme 500. Okay? When you consolidate, you don't consolidate schemes, you consolidate land. So let's give you an example. Let's say this was 0.4, and this was 0.4, and this is business 1 and business 1. If you consolidate these properties, they are still two separate schemes. So you can't go and put a 0.8 building there and put the parking here, because you're not consolidating land use. In actual fact, the legislation prohibits it. Section 92(5) of the ordinance and section 16(12) and the definition in the bylaw says that you may not exercise the right to consolidate if it will bring about a result which is in conflict with the scheme. So if you consolidate and the result is that somebody's going to do a 0.8 building here and put the parking there, you are contrary to that scheme and that scheme. Okay, so what we did is, in the bylaw, we made provision for the consolidation of schemes. So the architects normally are the ones who look at this and then they think, business for both sides, the property's been consolidated, and they do this. You can't do this. You can't plus rights. The reason for this is paja. If I live here, my only opportunity to have an objection was when this property was rezoned to 0.4. Do you advertise a consolidation? No. So you can't, by virtue of a consolidation, change rights that will affect me. You understand that? If it was on one amendment scheme, did I have an opportunity to say what can and cannot be done? Yes, because it was part of the conditions of the rezoning that it will be consolidated. Okay. Are you all on the same page here? Because this is the big problems that we have. So when we get the building plans, then we realize, okay, but the building plans cannot be approved because of the fact that there's this understanding that you can actually traverse land use rights once the property is consolidated. If you look at section 13 of the bylaw, you'll see that you can apply for a consolidation of schemes, but there are provisos to it. So let's say, I'm sorry, this looks very ugly. Let me get a new one. Or let me do it here. So let's say you want to go slightly over this boundary. So the 0.4 is going to be part of that, and the other 0.4 is going to be part of this. But now you can't consolidate, you can't go over onto that property. We will allow you to consolidate a scheme, 0.4, 0.4, business 1, provided that it doesn't affect this guy. If it is only to traverse a boundary and it does not affect anybody negatively on the outside of this property, then we will consider consolidating a scheme. Okay, but those are applications that must be brought by your town planner, but just to explain that when you submit a building plan, even if the properties were consolidated, the rights are not consolidated. Okay, next thing, what is the difference between a consolidation, especially you sectional title people, and a notarial tie? Notarial tie is nothing more than just an agreement. It's a tripartite agreement between the council and two parties. So notarial tie will say, the property shall be regarded as one property for all intents and purposes and shall not be transferred to another transferee other than the same transferee. Now, if you look at this, if you notarially tie, can you, for all intents and purposes, see this as one property if there are two different zoning schemes applicable? So please, guys, a notarial tie is not a solve-all for all your ills, because that's the first thing we get is let's just notarially tie, then we can spread rights and we can move it from here to there because now it's regarded as one property. It is not one property. It remains two properties with their rights unless the Annexure T made provision for it. If you want to understand notarial ties, there's a definition in the town planning scheme of what a notarial tie is. So do yourself a favor and go and read, because it doesn't mean that your rights spread across boundaries. Okay. If we're done with the notarial ties, maybe just the last thing. If you have a notarial tie in place and it says shall be regarded as one property for all intents and purposes, on what will you submit your building plan if you want to do a building there? Your building plan should be, because it's regarded as one property for all intents and purposes, you need to submit it like that. You obviously don't have to deal with this, but you need to show that it is tied and regarded as one property for all intents and purposes. Okay, because the tie agreement may have certain conditions to it. Say that you cannot exceed 200 square meters on this or whatever, for whatever reason. Can you tie a farm portion with an earth in a township? Yes, no? Okay, no. Why not? Because the rules of engagement are different. So an earth in a township is governed by the township conditions and a title deed with particular conditions. A farm portion has got a different set of conditions governing that farm portion. So can you regard it as one property for all intents and purposes? No, because the rules of engagement on an earth and the rules of engagement on a farm differ. Similarly, you can't have an agricultural holding and an earth being notarially tied, okay, because the rules differ, the conditions differ. Can you notarially tie properties where there's a road? So here's parking, okay, and there's a building and the parking is on this property. Can you tie it for parking purposes? No, because you can't regard it as one. There's something in between. So what do? You register a servitude. Okay, everybody happy with that? Yeah, because remember, land and zoning, it's a layer on top of each other. The consolidation of land doesn't change zoning, and the zoning, if you approve the zoning over two properties, it doesn't change the boundary. Remember, the subject site on the scheme remains the same subject site. And the nice thing about the South African registration and survey system is there's what you call a extension clause. You can always find what it was originally. And your original cadastre boundary is the one that we calculated when we did the amendment scheme. Okay, done. Okay, subdivisions. Okay, subdivisions are really problematic at the moment because of the whole issue of title deeds. Okay, so what people don't understand is rights attached to land and a particular land parcel You can't go and change the land use rights, and it's similar to the consolidation. So what we have currently is we've got a big stand, let's say it's Earth 200, and it was rezoned A, B, C, D. Now, when you rezone and you grant a zoning, you don't determine how ownership will happen. You just grant the rights. So if on this property you can have 4 units, you can have the 4 units, submit your building plans, and you can rent it out. You don't necessarily have to subdivide. So if somebody brings an SDP, that everybody's under the impression that you must do it on the subdivided property. That is not so. You can submit an SDP on Earth 200 because that is the zoning that was granted with the SDP condition. So if you don't have title deeds yet of portion 1 or portion 2, portion 1, portion 3 and 4, you can still submit your SDP because your rights are on this cadastral boundary. So where's your title deed? Do I need these title deeds? You can submit it with that title deed. And your rights can be exercised because on that area you can have 4 units. So we have this consistent fight where draft title deeds are submitted for these 4 portions as the SDP. We can't deal with the draft title deeds. Now, having explained to you SPLUMA and the fact that these things can lapse, can we take a draft title deed for a subdivision? No, we can't. Because remember, the subdivision may have been approved, but it's not registered. If the owner of that land does not comply with these conditions of subdivision, and the subdivision lapses, and we granted an SDP on draft title deeds, what will happen to this thing? It will be illegal because the subdivision doesn't exist. So we can't grant rights and applications on properties that don't exist. And there will always be a title deed. It may not be the one that you like, but there is a title deed for Earth 200. Okay. So if your conveyancer says it's registered, okay, and he gives us a draft deed, he will know the title deed number. So these things that I've submitted and I've done this and I've done that and here's my draft deed, we cannot rely on those things. We need some kind of assurance that it was actually signed by the registrar. Now, I don't know, I doubt whether there are any conveyances in here. Okay. Remember when you lodge a new title deed, because these things are new, if you transfer a property from A to B, the conditions don't change. But when you create a new property, the conditions are very important. Now they give us a draft deed. Then they go to the examiner or the execution hall and they sit in front of the examiner. And the examiner says, I don't like the way you did the servitude in this draft deed. I want you to do it differently. There's something called qualification of conditions, where this property is no longer subject to the condition because in a locality it is not applicable. So when they get there, they change those conditions. But in the meantime, you've given us a draft deed. So by the time that thing is registered, it can look different. So the council is exposed if we take draft deeds. So the best thing that you can do is to wait until it's registered. We won't wait for the release necessarily, but we can take a conveyancer certificate to say it was registered. Here's my title deed number. It didn't change. Here's the draft. It looks exactly the way it used to look, and it cannot be released therefore and then submit. But you cannot come with a pre-registered draft deed to us because it doesn't work. Okay. Everybody happy? Not happy. I presume you're not happy. So deed number, date of registration, because they know that, and confirmation that the draft deed that they are attaching is the deed as it was registered. You can have your STPs approved on the original stand as it relates to the zoning that permits you 4 units. So if you were to do something, let's say you were going to consolidate, you can do something like this almost and like that and just wait for, but then they're going to want a firewall and all kinds of things. We have regular meetings with the registrar. We are talking to the School of Conveyancing, Nicolene Le Roux, it's not family by the way, of Harvey Le Roux. So we've got regular engagements with them. The fact of the matter, it doesn't take that long. It shouldn't take that long. In actual fact, the registrar says to us 6 weeks for a release, which is good time. Yeah, for the release, No, well, the SG diagram, we've also got quite a good relationship with them. So the SG diagrams, depending on the quality, because there's rubbish in, rubbish out. Some of the land surveyors tell you they take 6 months. It's nonsense. If you don't do it correctly, it's going to be rejected with a note and you can't get it. So what Solo was saying, we are very reactionary. If you do your job well, then we can do our job well. We can't do it for you by keep on explaining what is missing and what is wrong. Same with the other government departments. Well, currently they say 2 months. I stand corrected. I can't speak for the registrar and the Surveyor General, but our experience is that they release the title deeds from 6 weeks onwards, and not more than 2 months for a SG diagram. Okay. So on the subdivisions, same thing then. So your subdivision is approved. You need to comply with your conditions of subdivision. Thereafter, you get what is called a section 1610 in terms of the bylaw. It's also called a section 53 in terms of SPLUMA, and it used to be called a regulation 38. That is a clearance from council to say that it is a serviced property. They can provide public road access, and it can be registered as a separate entity at the Registrar of Deeds. So that's the question you ask. Even before you start doing your drawings is, 1, this property, can you do the buildings like that just on the previous property? If your client doesn't want to do it like that, he wants to do it on the subdivisions, you're going to ask, are your rights in place? Did you comply with your conditions? Did you ask for your section 10? Because I'm going to waste my time doing this if you haven't gone through that process. If the section 1610 has been issued, your conveyancer can lodge, and he will then thereafter get his title deed. Okay, so those are the things of the bylaw. Section 1610, read with section 53 of SPLUMA, and in the old legislation, which is the ordinance, it's called the regulation 38. If it's a farm, it's a section 25. But we've got guidelines for these things. You don't have to remember all these sections by heart. We can show you how they are done. Remember, there's a huge court case with BMW. You must be careful with servitudes. If you've got a property that, for instance, is zoned residential 1, and you want to go and register servitudes, the moment your servitude, let's say you do that for parking, the moment the servitude makes it impossible to exercise the primary right, you can't register a servitude. Be very careful of that. You can't, by virtue of a limited real right, amend zoning. You understand that? The only means by which you can amend zoning is through an application for rezoning. So you can't go and register servitudes, for instance, for parking, if the property is not correct. Okay. Other limitation on servitudes, you can't register a servitude in favor of yourself. So if my development is there and I want to register a servitude for parking here, can you do that? No, because you can't register a servitude in favor of this property over this one if it is owned by the same person. Okay, so those are the rules. You can't do that. The other thing is to get to the parking servitude. Remember, you have to have your parking on site. If you want to do a parking servitude, you must get permission for off-site parking first, before you can register the servitude for parking. So there's a lot of rules regarding servitudes. Okay, and servitudes in terms of time frames, same thing as a title deed. Okay, 3 things about servitudes. Remember, they must be determinable, so you can either describe them, have an SG diagram, or do a notarial deed. If you do a notarial deed, it takes longer, okay, because you have to have further registration transactions. If you want to have conditions, so a question is, can you later develop this for something else? You can't, because you've registered a limited real right for parking. So let's say that is the residential and this is the parking. You can't develop anything on that thing until you've disposed of the servitude, because the right has been vested. So you can't develop that for something else if there's a servitude. You need to cancel it by virtue of a notarial deed of servitude. But sometimes you do get conditions whereby somebody says, I'll give you the servitude and I'll allow you to build a guardhouse and I'll allow you to build a wall, provided that the overall density allows for a guardhouse. If it's a right-of-way or municipal purposes or whatever, you limit it as to the limited real right that you have granted. So you can't just go and imply that you can do certain things on it. It depends on the actual servitude. Okay, can we move on? We'll do a day on servitudes rather. Obviously a little bit. Okay, so sectional title schemes. Sectional title schemes are the biggest headache for the municipality. So, Spluma has to some extent changed that as well. In terms of section 41 of Spluma, it says any application that changes the form and function of land is a land development application. So there was a huge debate as to whether Spluma has changed the Sectional Title Act, and does it now mean that you must submit it with the municipality. The general consensus across the country is sectional title scheme is sectional title scheme, but that the municipality now has oversight over these things. Because in the past, the land surveyor goes, he takes a piece of farmland, he opens a sectional title scheme, it's an illegal township, he just starts building. They've got all these weird and wonderful interpretations that if it was one dwelling per earth, if you cut it in 50 urban, it's still 1 dwelling per earth. Okay, so they've got all these weird and wonderful things. So the first thing you need to know is section 28(9) of the bylaw. You cannot do a sectional title scheme any longer by submitting a sectional plan or a sectional title scheme with the Surveyor General or the Registrar without coming to the municipality first. The municipality will determine whether your rights are in line with what you intend doing on a sectional title scheme. The problem, for instance, just to give you examples of this, if you've got these duets, I hate them, but nonetheless here they are. Okay, so first thing the person does, he's got an existing dwelling, so he goes for an additional dwelling or second dwelling. So he submits an application for a second dwelling. Then he goes and he sectionalizes. Now, a sectional title, you don't own the land, you own the section. You understand that? Okay. So there's section 1 and section 2, and everything in between is common property. So, how do we calculate land use? We don't calculate land use based on buildings. It's based on land use, how the land may be developed. So if you've got a 50% coverage, and this guy had 15%, and this guy's got 35%, okay, and this poor person wants to come and he wants to do a carport, or let's say an addition to his house of say 100 square meters, we will refuse him because the calculation of the coverage is not based on sections. It's about the coverage on the earth on which the zoning was done. So now this guy comes and he cries all these tears, but my house is 10 times smaller than my neighbor. How can I not do this? Or must I now rezone, or must I do this, or must I do that? With a sectional title, know and understand that you are in bed together forever. So firstly, you can't submit a building plan for that alteration without a body corporate resolution, because that piece of building is encroaching into common property. This is common property. So the bigger the building, the lesser participation quota you have. So your ownership is the building plus a share in common property. So if this guy increases his building, he reduces the share of the common property. So therefore, in terms of the Sectional Titles Act, you cannot go without a body corporate resolution to give permission that you may go into the common property. You with me? Okay, so that's the first thing. The second thing is, can you do this even if you are 15% and they are 35%? No, because you're beyond your 50% coverage. That's why we will go and check and see whether you've still got spare coverage in order for you to do the addition. Then, thirdly, can you just go and approve a building plan where there is a sectional plan? No. First, you must go in terms of section 24(6) of the Sectional Title Act. You need to extend your section with permission from your body corporate and increase your section on the sectional plan at the Surveyor General, and then only can you submit this building plan. So you've got a participation quota. Now, what you don't understand sometimes is that, remember, your value of your land is based on the value of your section plus your participation quota in common property. So by increasing this, his rate should decrease because his participation quota is less. So there are lots of things that happen, and what we get is we simply get this section coming and asking for a bigger, and they want to do this. So to try and assist building control, that they don't have to have arguments around the land use and the fact that you're exceeding your 50%, we have included section 28(9) so that you can go to them. They will verify the land use rights before you can submit your building plan. Now, just a few words on exclusive use areas. Do you know what that means? Most of you should. Okay. So, exclusive use areas. The Sectional Titles Act says you must have exclusive use areas. So, in actual fact, your parkings should be specified with your section. Now, what most of these sectional title scheme developments do is they don't register exclusive use areas. Okay? What they do is they put the parkings there and they rent this parking out to Section 2 because it's an income at 200 Rand a pop per month. So, as far as exclusive use areas are concerned, if you take this development, the duet, so this guy's got an exclusive use area, and because he's got an exclusive use area, does it mean he can do anything he wants on that common property? No, because it's a right on land. You can't, the fact that you've got the right, it's like a servitude. The servitude is over that land, but the underlying property is still owned as common property. So he still needs, even if it falls within an exclusive use area, he still needs a body corporate permission. Okay. I hope you all, guys, everybody's very silent on this. So I'm telling you, either I'm telling you something you already know, or I'm not explaining it right. The Surveyor General says they don't care. In the past, they would use, as long as they've got a building from which to measure, they actually don't care whether they need a specific building plan for this before they can do your sectional plan. As long as there's a building, they can actually do it. So your first step is your 28(9), then you can do your sectional plan and then your building plan. Some people would like to do the building plan first, But then it must be made subject to the sectional plan being amended, the section 24(6) extension. Okay. So that's the right sequence. So your building plan must either be made subject to the sectional plan being amended, which I don't prescribe to, or they need to change the sectional plan first. And as I said, the land surveyors I've spoken to, they say as long as they've got an outhouse there, they can draw a section. They don't need a building plan to change the sectional plan. Yeah, they need a structure. So if the old structure is there, they can survey and they can increase the section. Quickly, just two things. So the 1 meter on any boundary other than a street boundary, even if it's not in your title deed, it's in the scheme. So remember that. The scheme says all urban are subject to a 2 meter servitude on any boundary other than a street boundary. So if you look at your title deed and you don't see it there, you still need to keep it in mind. So if you've got two properties and there are mid-block servitudes, okay, like this, because that can happen.
You're saying this by implication?
By implication, the moment you've taken, this is what we call an unidentified servitude. Eskom does this a lot. So they say, I want a 2 meter servitude on any boundary other than a street boundary. If the services were taken up, it means your other boundaries are released automatically, because you are only entitled to one servitude if that's the condition on any boundary other than a street boundary. What in Joburg they, for instance, do to release these other boundaries, they do what is called a notarial deed of identification. So they identify where this 2 meter servitude is going to be, and ad infinitum, forever, you are then released from having to worry about encroachments there. And it's becoming more prevalent because on a small stand, if you've got a 2 meter servitude on any two boundaries, it means the area that you can develop becomes so small, so you don't want to release at least one of them so that you can develop. Then you do a notarial deed of identification and you identify. That's what Eskom does. So they've got a servitude, just a general servitude, and then when you develop, they go and they pin and they say, this is where Eskom wants it. Okay.